and understand that every
Okay. Okay, so for the people on Zoom, do you see my screen, the residential listing agreement?
Yes, see
Yeah,
it.
we see it, Simon.
Okay, wonderful. Thank you so much. All right, well, let's go ahead and dive deep in it. I have less than, well, I'll say about an hour of lecture regarding this. So we're going to dissect the listing agreement. I know we go heavy on the purchase agreement, but I think it's also important to understand the elements of the listing agreement, you know, because all of us definitely want to have more listings because it's a little bit more easier to facilitate more sellers than it is more buyers. And that definitely carries a lot. If you are getting listings on a regular basis, right, you're going to be showcased as the local agent that the community sees because of your for sale signs and your open houses. They're going to say, yeah, you know, this individual real estate agent is doing a lot of business here, so maybe we should have a conversation about us deciding to sell our home. So I'll go through the basics, and if you have any questions or anything that I can address, please just say, Simon, I do have a question for you, or put it on the chat. I'll consistently be checking for anything on the chat as well. Okay, so let's go into it. So the residential listing agreement, make sure that you have the most current, which is December of 2024. Now, with that being said, there's always two changes every year. One happens in June, the next one happens in December. So what I'm talking to you today may be different tomorrow, right? Now, June is just around the corner. We have, you know, the ends of April, then we go into May and then June. Usually around the midst of June is when we see the changes. And what I'll do is I always give updates of all of the redlining of all of the forms, any modifications to the forms, anything removed from the forms, or any brand new forms that are added to our library, okay? So it starts off with the data preparation, right? You know, that's the time when you actually start the actual zip form of the residential agreement, okay? That doesn't mean that's the date that you're gonna have the seller sign. That's just the date that you prepare this form, okay? That can be today, that can be yesterday, that can be a week from yesterday. That just tells you when the data preparation of this form, okay? This is an exclusive right to sell, okay? Meaning that whoever brings a qualified, ready, willing, and able buyer means you're still going to get compensated, okay? So if the seller brings a buyer, if the neighbor brings a buyer, it doesn't matter. You're still secure to get a compensation. Now, with all of the changes that happened last year, nothing on the new listing agreement emphasizes of cooperating compensation to any buyer broker. This is why all of the changes happened last year. So there's nothing on this listing agreement that's going to talk about paying a buyer agent, okay? And we'll have a discussion later on in how you maneuver those type of questions if you are talking to the seller and if the seller is asking you those questions. All right, the first part of it is pretty self-explanatory. You're going to put in the name of the sellers, right? So who are the sellers who are authorized to sell the home, right? And you want to make sure that you have all the people that need a sign, right? How do you research? Well, you go into the MLS, you go into Realist and see who are the proper owners, okay? Because they can be one, it can be two, or it can be multiple people than just one and two, or a husband and wife. So otherwise, you don't have a valid agreement. So you want to stress and emphasize the importance that you have those conversations. And more so, when you go on a listing appointment, folks, okay, ask if all the people that are the decision makers, but also on title, are going to be there, right? Because you don't want to just have a conversation with the wife or the husband and the other party is not there, right? Because then one, you're not going to be able to do anything if you only have one signature, right? You need to have everyone that's entitled to sign off on these agreements, okay? Usually it's husband and wife, usually it's a single person, right? But if there's more than one person, more than two persons, more than three persons, then they also have to be in agreement. Otherwise, you don't have a right to list the home. Okay, make sense? All right, the brokerage or the broker means, your own real estate company, right? So Keller Williams, I just kept it very neutral. Then the next is obviously the address of the property, right? For the sake of today's class, I'm just using a generic ABC street, City of Torrance, Los Angeles County, zip code. The next one is the parcel number, which is very important, right? The APN number, it's like a social security to us, right? That's what identifies this particular property. And I want to stress and emphasize the important that coincides with the subject property, because if you have one digit off, that can throw everything off on your part or even on the escrow process, all right? And I've seen errors and mistakes that happen because they don't double check, triple check their stuff. So make sure that whatever you have as the APN number reflects the subject property's address. Make sense? Okay. Now we go into the terms of the listing agreement. Okay. So this is what we call the grid. Similar to the purchase agreement, we have what's called the grid. Those are the titles and contracts and terms and conditions of what we're saying we're going to be doing and what the seller is going to give us the authorization to do. Make sense? Okay, it starts off with 2.1a, right? Listing period. And it also has an emphasis maximum length. Okay, so they put that as a stipulation to this agreement. So this is where you're going to start the actual active of the MLS. Beginning of or beginning on means the date that it's going to go live. Okay. That's the day that it's going to go live, right? The ending date is by 11:59 p.m. That's going to be the ending time, meaning that's your period. If it's a 1 month, 2 months, 3 months, 4 months, 5 months, whatever the case may be, that's where you're going to put in the beginning date and also the expiration date. That's when it expires. If you don't sell it, then it'll expire. In this case, I put April 28, 2025, and it ends on August 4th, 2025. Now, it also says here, not to exceed. Okay. And if you read what it says 24 months if approved with 1 to 4 units and not owned by an entity. If listed period exceeds 24 months on a residential 1 to 4, this agreement is void unless seller is a corporation. So if you're selling a property that is a corporation, then disregard this. But if you're just selling it from a, home buyer, excuse me, a home seller, husband, wife, brothers, sisters, whatever the case may be, then you cannot exceed the listing agreement. The most is 24 months, meaning 2 years. Okay. I don't see why you need 24 months, right, to sell a property, right? If you price it well, then it should sell within 21 days or sooner or later, right? But it also emphasizes that this agreement only has a maximum of 24 months. Okay. Then the listing price, that's what you and the seller agree on, right? After doing your listing presentation and providing comparables regarding the properties, apples to apples, and it's fair for the seller and it's fair for you. Because remember, it's a two-way street, right? If the seller is not being realistic on the price and they believe that their home is worth $10 million, but in essence it's only worth 900,000, that's not a realistic seller, right? The expectations need to be, and this is where you have to take ownership and make sure that you and the seller are in agreement, right? Because I'm not going to take a listing for the sake just to have a listing if I'm not going to be able to sell it. Remember, I'm not in the babysitting industry. I'm in the selling of the industry, right? My job is to help sell this process, or excuse me, home, so that way we can move on the next, right? So this is where you have to understand every component of how to run an efficient comparable market analysis, apples to apples. So that way, now you can present offers to the seller. So whatever the price is, that's what you're going to put. Section B goes into the specifics of the listings. It's already defaulted into those, 1 to 4 units. But if it's a manufactured mobile home, then you're going to check. If it's a probate, conservatorship, or guardianship, then you're going to check that specific box. Okay. Now, Section C goes into compensation. Okay. And it's graded in gray, and it says the following, that the amount of rate of real estate commission is not fixed by law. Okay. So one, the amount or the rate is not fixed, meaning whatever you and the seller agree to, right? It's between you and them. You're going to do the heavy lifting by marketing, negotiating, getting it in an escrow and going through the initial process, right? But it also means that, between the seller and yourself, you guys need to come to an agreement that you're comfortable in promoting it and helping sell the property, and the sellers are willing to write, a commission for you. Make sense? Now, it also says that it attaches the broker compensation advisory BCA, okay? And we'll talk a little bit more about that. Section C1, okay? And if you look, it also has C1, that's the paragraph, right? That's the actual, excuse me, that's the actual column, right, of the paragraph of this grid. Now, what I like about these new forms is one, it has the paragraph. So if you want to know a little bit more of what that specific statement says, go where you see C1, right? C1, and then look at 4B, okay? Then you go to 4B and it'll explain what compensation to seller means. Make sense? Okay. So here is where you're going to put what you're going to want to be, or what you want to charge the seller. Okay. So that's where you're going to put 3%, or if you're going to put a flat fee, then you can put a flat fee right here. Okay. So this is securing your compensation, right? Mr. Mrs. Seller, in order for me to help sell your property, give you top dollars, what my compensation of doing this is going to be 3% of the sales price. Okay. Any questions? You can also attach a broker created compensation schedule. If you want, then you would check that and then you would provide that. Mr. Mrs. Seller, if I bring you this amount, then my commission will be this. If I bring you that amount, then my commission will be this amount, right? So you can do kind of what's called the scale process. All right, so this is where we get a little bit of confusion is section C2. Okay. Section C2 goes into additional compensation to seller's broker if buyer is unrepresented. Okay. What does that mean? Well, it means that if a buyer comes to you at an open house and you ask the question, are you working with an agent? And the buyer says, no, I'm not working with an agent. You don't have any agreements with any, you didn't sign anything. No. And they want to submit an offer. Okay. One, you have two options. You can make that buyer a client, or you can make that client a unrepresented buyer, meaning you have no relationship with that buyer. Because remember, your interest, it's still with who? The seller. Yeah, the seller. That's who you need to protect. That's your responsibility, is to take care of the seller's best interest, right? Here they put, this additional language in here that allows you to get paid. Now, what does that mean to get paid? Isn't that considered, me representing the buyer, technically speaking? Well, yes and no. Okay. One, you don't have a buyer agreement with a buyer, right? What's better known as the BRBC, right? The buyer representation agreement. So you can convert that potential unrepresented buyer into a represented buyer, right? Now that creates what we call dual agency, right? Dual agency, now we are one agent working with the buyer and the seller, right? If that's the case, you're not gonna worry about this paragraph here, because that doesn't create a non-represented buyer. Now, if you are going to ask for additional compensation, then again, going back to the amount of rate of real estate commissions, it's not fixed by law, right? So you can charge what you feel is worth your time to represent someone that is not being represented, meaning you're going to have the dialogue. So what this means is I'm just going to push paper to the buyer. Buyer, we're not going to have any interest in, helping and navigating this, right? You're gonna do your own due diligence on this, right? I'm not representing you, so therefore I would encourage you to speak with maybe an attorney or get some advice and how to maneuver the process. I'm only gonna provide you with all of the paperwork to help my client, the seller, in selling their home. Does that make sense? Okay. So here, you're going to put whatever you feel you're worth. If it's 1%, 2%, 3%, that's your discretion. And again, on here is if you want to charge flat fee. Okay. Any questions on 4C?
Just a question, Simon. Is there, I think you mentioned this before, but is there a way we can agree with the seller not to bring unrepresented buyers?
Um, Repeat the question. I'm sorry.
So can we have it in writing that in case there are unrepresented buyers that we don't want to work with them, that we don't get their offers? So this way we could force the buyers to be represented when they want to submit an offer.
Well, I would probably discourage you from putting something in writing because if you put something like that, what if this buyer doesn't want to work with any agent and it's a sophisticated buyer? Meaning, let's say myself, right? Many years of experience, know the ins and outs, but I'm going to submit myself as a non-represented client, right? I don't need representations because I can read and understand these agreements, right? So by putting a stipulation on the listing agreement that says to the seller, hey, by the way, if they're not being represented, right, we're not going to consider their offer. Well, I don't know. I think it does no justice to the initial process. I would say that the best approach is that's fine. If you want to work without any representation, and they understand every component and the risk involved, because there's always going to be a risk, right? There's a risk even with two agents involved. But if they want to go because one, they don't want to pay compensation because technically speaking, the way the forms are created now, the buyer is responsible to pay the buyer's agent compensation. Now, theoretically speaking, we ask the seller to pay us under the purchase agreement, but under no circumstances does the seller have to pay a buyer agent compensation anymore, right? So three things can happen. The seller can accept, the seller can counter, or the seller can reject compensation. And that's under paragraph 3G of the purchase agreement, right? So it all really depends, but in me and seeing that question, I would not put anything that says they have to work with an agent. I hope that kind of answers your question.
Yes, thank you.
Yes, question here.
So you're saying that once we get to that, we give the new buyer the option. We tell them these are the options coming in because you're unrepresented.
Well, yeah, and this is why you want to have those qualifying questions, right? One, if you're hosting an open house, the first thing we should be saying is, well, what do you think of the property? Oh, I love the property. Well, is it something you're interested in maybe submitting an offer? Yeah, I think so. Are you working with an agent? No, I'm not working with an agent. Would you like to work with an agent, right? Because sometimes even the agent that's hosting, right, hosting the open house doesn't necessarily the listing agent, right? So what's the purpose of doing open houses is so that way we can secure a buyer so we can submit on behalf of the seller, or at least as the listing agent, right? But let's just say, theoretically speaking, you're hosting your own listing and doing your own open house, and a buyer comes in, but says to you, look, I'm okay submitting an offer. I don't need representation. One, I don't want to pay a commission because, again, the way the contract says and the buyer representation agreement clearly states there that the buyer is responsible to pay you a commission. Now, there's also language on the BRBC that says that if anyone other than the buyer credits you compensation, therefore it offsets the cost of the buyer's obligation to pay you. Meaning, let's say that you submit a request of 2.5%, and on the buyer representation agreement, you put 2.5%, and the seller says, I'm willing to pay 2.5%, that squashes the buyer's responsibility to pay you because you're getting the compensation from the seller, which goes back to the traditional way of doing business, right? That's how it works. But let's just say that I submit an offer of I submit an offer of 3% and it gets countered and I'm only offering 2%, meaning the seller's only offering 2%. Well, there's a 1% discrepancy, right? Well, the way you can structure it is the seller can pay you 2 and the buyer can pay you that 1 for your total of 3% as you originally agreed. And the buyer then would have to come in with the additional funds into escrow, down payment, closing costs, plus that 1% into escrow to make the deal work. You get the best of both because you'll get the 2% from the seller, but also that 1% from the buyer, because that's the way you structure the buyer representation agreement, right? Now you have that discretion and that option as well, ladies and gentlemen, meaning that, yeah, you might have put 3%, but I would encourage you, everyone, put 3%. You should, that's you should earn it. You know, you're a professional. Put it on the buyer representation, 3%, and hope that the offer and the commissions sticks to the wall. If they come back and only offer 2%, right, or 2.5%, now you can have that conversation with the buyer, is if they're willing to, you know, make this work and say, yeah, look, we got the offer accepted, but under these circumstances, price terms and conditions were accepted, but now we just have this little cloud, which is the difference of the commission. Are you willing to pay? Well, I don't have that amount to pay you. I barely have enough to pay my down payment and closing costs. You can make that discretion at that point in time and say, look, I'll squash it. I'm okay just collecting the 2.5%. So then there, you're going to do what's called a modification of buyer representation. Because remember, you had it at 3%, the seller is offering 2.5%, right? And now you have to modify because it has to be in alignment to what the seller's willing to pay only. It cannot be more. If the buyer's not willing to pay more, then you have to mirror what the seller is going to pay you. Does that make sense? Okay. Now going back to, again, the unrepresented, right? And there's pros and cons to it, right? And you can look at it from all angles when it comes to an unrepresented buyer, meaning you have no whatchamacallit, no agreement in anything that you as a real estate professional have to offer the buyer. Now, you're just basically pushing paper. That's all you're doing. You can also help with a purchase agreement and still not have any fiduciary duties to that buyer. You're just doing it on behalf of the client, your seller, to get the process to the finish line and close the deal for the seller, not for the buyer. But you as an agent can facilitate that. Because let's just say that the buyer says, look, I don't need representation. I'm willing to use a generic purchase agreement. Here's my offer, right? Well, a generic purchase agreement may have a lot of loopholes and that benefits the seller, right? It may just benefit the buyer. And if you accept that, then those are the terms because it's mutual agreement between the buyer and the seller, right? So I would caution you to always, always use C.a.r forms, right? Because it protects the seller, protects the buyer, protects the agents, protects the broker. And there's a lot of languages there about certain stuff. The loan, the financials, the contingencies, the do's and don'ts. So if an offer comes in from an unrepresented, that's a generic offer, you counter that and say we're not going to use that generic, but we're going to use C.a.r form RPA, right? The residential purchase. And you have that right to do so as long as you're negotiating and put it on the contract. Does that make sense? Okay. Yeah, that's for everyone. Yeah, for everyone, especially investors, because they have a lot of disclaimers, loopholes, strategies that are interest for the buyer, not necessarily for the seller. So yeah, if a buyer submits an offer on a generic purchase agreement, I would counter that out. That's going to be removed. We're going to use the California residential purchase agreement. And then you can help in the submission of it, buyer, what do you want to offer? Okay, and then you can go through the channels. This is why you're getting paid additional compensation to service the buyer, not represent the buyer, but to service the buyer to get the property to the buyer and the seller to close the deal. Does that make sense?
Yes.
Okay, very good. All right, the next is the section 3 goes into the continuous of rights to compensation for broker and identifying a prospecting buyer. So it's basically a safe clause. Okay, never, never, never leave it blank. Always put a number. Okay, I typically put, not that, typically put 120 days. Okay, and the reason is you just never know, right? You just never know if this buyer goes sideways and ultimately goes behind you. And you want to protect yourself. This is why we have that protection clause, meaning that if the buyer or you decide to cancel or the agreement expires, right? And they come back and submit an offer to the seller or any properties that you showed the buyer, you still may be entitled to compensation. Okay. So let's just say, and I'm going to use you, Ali, as an example, right? I'm working with you. We don't necessarily have a buyer's agreement in place, but I have, some type of, oh, excuse me, and I apologize. I'm thinking of the purchase agreement. This is again for the seller. So let's say that Ali is the seller and the listing is about to expire, right? Or we decide to cancel because we cannot sell it. That safe clause there protects me and protects the seller that if during this time after the expiration or the cancellation of the listing agreement, a buyer comes back that we showcase, right? We either hosted an open house and they saw the property, they submitted an offer, then we have every right to go after compensation from the seller. Okay. And this is after it expires. This is why you want to put that number, and it has to be agreed upon, because if you put, 365 days, a year after it expires, and the seller signs, then congratulations, then you have that buffer for 1 year. But this is why this page is initial from the seller to make sure that the sellers acknowledge, understand, and approve these agreements. And if there's not an agreement, then you have to modify this as well.
The
Okay?
compensation you get is based on the listing price. Is that correct? Not uh, the number that it was sold for.
Yeah, it's only based on the commission. So, and that's a good valid point, because let's say it's 975 that we had it listed, right? And now the seller sells it to another party and they sells it for a lot less or a lot more, right? It's based on that commission price, okay? Not based on this, okay? Yeah, whatever it sells for is what you would get paid for. So if you find out that it sold for $1 million, then technically speaking, because that buyer, right, that buyer that you either showed or submitted an offer, went back and bought this place or is an escrow, then whatever they're in contract, then we're entitled to the commission based on the purchase price. Okay, that's typically how it works. Yeah.
What about the investor? Are they getting chances of, and they're, if they want to send it out for cash, close 14 days, they want to submit it. It's obviously you're not going to represent them. Sometimes I get text messages where they want to be represented, so that's why
Yeah, no, it's a valid point, Ellie. And this is why you want to protect and really read and double check these forms, because this little mishap, I know it happened to one of our agents, that one, she didn't have on the listing agreement, she didn't have an expiration date. And what ended up happening was that the seller ultimately went radio silence after months and months and months. And she kind of just forgot about it, thinking, you know what, they just decided to not sell it. And then, like a year later or 6 months later, I can't remember, she found out by doing a little bit of research that the property sold. Okay. And when we, and I, it was a long shot. I told her there's probably not an opportunity to collect because one, you didn't put an expiration date. Little things like that. So I says, look, just to pacify her, let's go ahead and have an attorney talk to you and consult you. And immediately the attorney says, look, yeah, you don't have a case. So she was very devastated about that. But that's again why it's so important, folks, that you fill out and if you don't know, ask the questions, okay? Because these little small, like the continuing period, that's an important component to this listing agreement. Because there's a lot of sellers that will try to go behind you. They find a buyer and they don't want to pay compensation. They'll try to maneuver that and wait until the listing gets either canceled or expires, and then they try to open up escrow. And I see that quite often. And then we don't have any leg to stand on because we didn't put a stipulation. Now, there's also other components to that as well. Just because you put 120 days after it expires or cancels, you still got to provide the seller with a prospective buyer list, meaning you got to know how many people either submitted an offer, right? So if you have 10 purchase agreements, part of the cancellation or the expiration when it's about, send all the offers to the seller. Okay, so that way, full transparency, the seller has copies of all of the offers. So if any of those buyers come back and buy it, doesn't matter if they're being represented by anyone or other agents, you still may be entitled to go after compensation on the seller.
Simon, quick question.
Yeah. Yes, sir.
When you say to submit all the offers to the buyer, some agents will maybe put it in a like a Word document and just kind of give them a breakdown rather than giving them the full RPA. And sometimes agents won't give their clients the actual name of the people who are submitting the offers for, that way they don't discriminate in case they look at a name that they don't like, etc. So how can you work around that in case you do have an issue down the road and you never gave them an actual name, but you gave them what the offer was?
That's a good point. So let's reference where it says 4D2. So let's go to 4, okay, 4, and then go to D2. Okay, so let's read what it says here. And it says continuation of rights of compensation for broker procuring buyers. And it says if during the continuing period specified in paragraph 2C3 or the same period of time after any cancellation of this agreement, unless otherwise agreed, seller enters into contract to sell, convey, lease, or otherwise transfer the property to anyone, and it says prospecting buyer or that person related entity, one who physically entered and was shown the property during the listing period or any extension by the broker or any other broker, or from whom broker or any other broker submitted to seller a signed written offer to inquire, lease, exchange, or obtain an option on the property. Broker right to compensation pursuing to this paragraph shall only apply if prior to, and it says prior to expiration of this agreement or any extension, broker delivers to seller a written notice of the names of such prospecting buyers. Okay, I can't emphasize any clearer what this means. And if you miss any of the steps, then unfortunately you don't have a claim against compensation. Okay, so these are the steps in order to procure and get paid if the seller does sell the property to anyone that you potentially might have procured during the listing period, right? So if it's 6 months, a year, you provide the list of, that's why I'm saying, and you're right, I was maybe going a little over the top when I said purchase agreement, but it's just best to just send everything so the seller has documentation. And that way, if we have to challenge potential claim against compensation from the seller, we provided the seller with all of the offers that we got. And sometimes agents get a lot of offers, right? Does it mean that the seller doesn't accept, right? So many things can happen, right? Then the seller decides to cancel on us and goes left field on us. And then a year later, you find out that this property did end up selling, right? Well, remember, it's within that time. If you can articulate and have the proof and evidence that it happened within that expiration period, then yeah, we can definitely go after compensation to the seller. Now, it's far and few, and it may be difficult because if you don't catch it soon, then it's going to be a long shot, right? You might as well not even, waste your time, in my opinion. So I hope that kind of answers your question.
And Simon,
Yes,
also it sounds like it's not just people who've written offers, but also anyone who's entered. So if you have a list of those people, even by any other agent, correct? So if
100%.
somebody comes, yeah,
Yeah. Anyone. So even if a buyer is represented by, say, ABC Realty, right? As an example, they submitted an offer, but their offer wasn't accepted. And now the listing gets canceled or it expires. And then that buyer with that agency comes back and buys it, and it's within that 120 days or whatever that time frame that you put, which again, 4 months is my kind of my buffer, then yeah, you can challenge and go after compensation from the seller. Okay. So, and you definitely have a claim because black and white, but remember, you have to provide um, a prospecting list of all of the buyers, right? Even in open houses, this is why I stress and emphasize the importance of documenting and having a registry, right? Because you want to put all of the buyers that come into the open house because you just never know if those buyers are going to come back and buy that property. And because you were the procuring cost of it, that ultimately the buyer decided to buy the place. Um, and we had this stipulation and we provided the purchase agreements or a list of all the buyers that seen or submitted offers, right, including open houses, then we can go after compensation. Okay. All right, let's continue. Seller obligation to pay previous broker. Okay, so when you're on a listing appointment, let's just say that this is an expired listing, right? And this is the safe buffer for the seller, right? Because we talk about the continuance right of compensation, but then Section C.4 really reinforces that says to the agent, hey, I'm willing to give you the opportunity to sell my home, but here's what I want to put as a stipulation. And that stipulation is that my previous broker, right, ABC Realty, whatever that company is, and the name of the brokerage, and anyone that I provide you of lists, if these individuals come back and buy, then I'm not entitled to pay you commission. But anyone else you bring that's new, then I'm okay to list it with you and pay you compensation. One, it's telling the agent is I'm protecting myself as a seller. I don't want to pay double commissions. Okay, because in essence, you're paying two commissions. So I'm going to put that buffer. If I'm a seller and I ended up canceling or the listing expires and there's that buffer and I was provided with the list, and then I'm just going to throw that to the new agent that represents me saying, hey, Mr. Agent, Mrs. Agent, I'll list with you, but here are my conditions. If this brokerage and these named buyers come back and buy it, then unfortunately, I'm not obligated to pay you compensation. That's what that provision means. Okay.
So here we can also, are you saying that we can also add like so other brokerages or whoever it is, or just brokerages?
Yeah, so this section it says, look, and let's go to 4F because I think it's easier to explain. So if we go to 4F, And it goes into seller compensation, obligation to other brokerage, right? So here, seller represents the seller has not previously entered into a listing agreement with another broker regarding the property unless specified on 2C4. Seller warns that the seller has no obligation to pay compensation to any other broker regarding the property unless the property is transferred to any of the individuals or entities specified in paragraph 2C4. If the property is sold to anyone specified on that 2C4 during the time seller is obligated to compensate another broker, broker is not entitled to compensate under this agreement if two, broker is not obligated to represent the seller in such a transaction. So what this basically states is that, hey, I'm just disclosing to you that I'm just protecting myself because I don't want to pay additional compensation. I'll pay you if you bring me a ready, willing, and able buyer, but I'm not going to pay you if I have to still pay my previous broker because that buyer came back and bought it. Okay. Now, it's far and few that happens. But that's the protection from the seller because they don't want to pay double commission. Okay. I hope that kind of answers your question.
But I mean, what if they tell us that they're already talking to their neighbors and they want that they might be able to close the deal without needing us? Can we put the name of the neighbor somewhere to?
Yes.
Okay.
Yes. Absolutely. Yeah. Here's the other one, and thank you. So let's just say that I'm on a listing appointment, right? And I'm the seller, right? I had it listed and I'm going to provide that list, but I also will tell the agent, listen, my neighbor has been interested in my property for many years. Okay. I might lean of selling it, or I might be wanting to sell it to one of my family members. Now, as part of my agreement with you, I'll give you the listing, I'll give you the opportunity to sell my home. But I also want to put this stipulation on this agreement that if my neighbor, John Doe, okay, or my family member, okay, decide to buy this property, then I'm not going to pay you compensation. I'm already putting that in front of you. Okay. Therefore, then yes, the seller is not entitled to pay us compensation. Okay. Now, you can look at it from two different angles. I'm going to be asking a lot of questions. Well, how serious is the neighbor? How serious is the family member, right? Well, it looks like they're going to buy it. They're already starting the initial process. Are they being represented, right? Because then you can use that angle and say, maybe I could represent them and help with facilitate the paperwork and do it for 1.5% or 2%. I don't know. I mean, there's so many scenarios that you can go with this. But to answer your question, 100%, 100%, guys.
And
Yeah.
like, is there a place where we can fill it? Just that was my question.
Yeah. You can put it
Oh.
on additional terms. You can add an addendum to the listing agreement, where you can say a laundry. You can put 20 different buyers in there. If these 20 people come and buy this property, I'm not responsible to pay you compensation. Okay. And that's what it means. So it's a safe haven and a protection for the seller. Yes, it is. Okay. It is. Because let's just say you are a seller, right? You are the seller selling your property. You don't have no real estate experience, but you kind of understand some of the elements of it. But if I put a list of people says, look, if this person, because all my neighbors want my property, okay, and if neighbor 1, neighbor 2, neighbor 3, neighbor 4, neighbor 5 buy it, then I'm not paying you compensation, and I'm going to put that in writing. I have to be okay with that, meaning me as the listing agent. Not a problem, okay? Because the likelihood, right? It may be a 50-50 chance, right? That the neighbors will buy it, a family member will buy it, or I sell it to someone other than, the list of people. So you have to be okay with that. And you can put that on additional terms, and I'll show you in a little bit. Okay, so any questions regarding C4? All right, item D as in David, items intended to be included and excluded. This is where you need to make sure you understand this because I see a lot of issues with this on the MLS. What the seller believes is going and the buyer believes is staying, and now it compromises. And guess what? The agents are writing checks. Okay. Because they made a mistake and now they have to pay for an appliance that they thought they were going to have as part of the process or part of the sale. So be crystal clear, ladies and gentlemen, in how you maneuver these listing agreements, because the essence is any little thing that you make a mistake is going to cost you, and you're going to end up writing a check. Okay. Because you messed up and the only thing is taking ownership to it, right? Not saying that an appliance is that expensive, what maybe $1,000, $1,500 for a nice appliance, at a refrigerator or stove or stuff of that nature. But whatever you believe that you need to have that conversation with the seller, have that conversation. This is the point in the time of conversation is what is included, what is not included. All right. Because a lot of people think that this is going to be included, right? And that may be the case, what's bolted down, right? Like this television as an example, right? It's anchored to the wall, right? So the assumption is, right? The assumption is that that it's going to stay with the property. But let's just say that this television is 150-inch TV, right? And this bracket only fits this particular TV, and they're not leaving the television because they want it for their new home, right? They may take the bracket. So what do you do with that situation, right? Well, before you even put it on the market, you're going to take that darn television and the bracket, patch up, paint, whatever you need to do, or replace it with something else, right? That will be staying with the property. Okay. That's what you need to do. So be crystal clear on what the expectations of what is. Mr. Mrs. Seller, what is going to physically stay with the property? Okay. We already know that the carpet stays, right? We already know that a lot of the light fixtures stay, right? But be very specific of what is included and what is not included. Okay. Because I think it's very, very important. I raised the heat for you. Yeah, sorry. Or you may want to switch too, because I know you're right on the vent. Okay. All right. So then we go into the lease. If there's any lease, solar panels, again, ask questions, be vigilant, check, double check. Okay. If you see solar panels, okay, that's an indicator. Is it purchased already, or are they leased? Are they transferred? What's the initial process? Start proactively, even before it goes live on the market. Is that we start the initial understanding of what that looks like when it comes to solar panels, because sometimes these solar panel companies are out of business. And, we need to track down, is there a lien against the property? So these are vital and important things to understand before we go through the motions of transfer, because that can delay the process and ultimately kill the deal because there's not a meeting of the mind. Anything if there's any liens against the these certain things like the HVAC, the solar panels, then you want to emphasize and stress that as well. Section D5 goes into smart home features, right? A lot of us have Google gadgets, a lot of technology, right? Is it going to stay or is not going to stay? This is the time to put it in writing. So that way you know what is staying and how you're going to draft the information on the MLS. Because if it's not staying, you're not going to put that is part of it, right? You're going to exclude it from it because that's now what the seller's wishes are. Then we go into the MLS and public marketing. Okay, so here on section E1 is who is your primary, right? You may have secondaries and you may be part of many different associations. They're asking is where's the specific property going to be put on? I would say that if it's going to be your primary, right, which is CRMLS, but if you're using other platforms, right, like homes.com or apartments.com, and that's going to also be part of it, I would just say, look, as a value incentive to you, Mr. and Mrs. Seller, here's some of the information that is going to be broadcast, right? Even just putting on CRMLS or CLAW is perfectly fine. You just want to show transparency to the seller that you're doing everything to promote their property. Section E2 goes into publication of seller's willingness to consider concessions, okay? So here, if checked, this is the component that I want to be clear to is because a lot of agents are under the misunderstanding that now they can put a percentage of compensation on agent remarks. The answer is no. That is against the rules and regulation of the NAR settlement, but there is a toggle on the MLS that says seller is willing to pay concessions, and it says yes or no. Okay, so if they say yes to that, then you're going to check in the MLS above permitted by the MLS. In any other marketing outside of the MLS, then you would check this. That will allow you to put that, because right now it's a default. Okay, it doesn't say yes or no. You have to either put it as a no or as a yes. If you leave it blank, then it's neutral. It doesn't really matter. Now, when I'm looking at the MLS, I'm looking for, is the seller willing to pay concessions? But we're not going to put what the percentage looks like, what the flat fee is. It's only yes, the seller is willing to pay concession, because concession can mean many things. Concessions can be towards buyer's closing costs, repairs, termites, and also buyer's compensation. Okay, so that's kind of a universal position when it comes to publicizing the willingness from the seller to pay compensation. Seller instructs broker not to take or use photos and marketing except as required by the MLS. So if they're adamant that they don't want more than what's required by the MLS, then you would check this box here. Okay, but it's very likelihood that the seller won't want to expose their property. Initials, and then we go on to the next one. Next is time of presence of offers, right? So this goes into sellers instructing the broker to present all offers received as soon as practical or offers to a future date. So this is again one of the cool statements here that allows us to say to the seller, listen, as offers come in, do you want me to present them to you? Okay, or as offers come, you want me to wait into a certain date. Then we can present all offers. And some agents do that is so that way they're not bombarded with, offers constantly coming in. All offers will be presented to the seller on one given date and time. So again, that's a conversation you're having with the seller, and the seller makes that ultimate decision if they want them as they come or they want them all in a specific date and time. Does that make sense? Okay. Buyer supplement offer letters. Okay, this is again seller instructing us not to present letters, or seller instruct broker to present buyer's letters. Okay, so if that's the case, then you would check it. Investigation of reports. These are pre-inspections. Okay, and one of the good advantages of doing this is being proactive, but it's also to really disclose to the buyer any and all material facts against the property, right? Not that the seller has to do any pre-inspections, but it's also important to know that, hey, if I haven't lived in the property for many, many years, I think a thorough inspection of the property will give me a generalized idea of what issues that the buyer may come up, because they're going to do their own inspections. And this is a good way to present this, because now the seller knows some of the issues with the property, and now they can either fix them before they even go live on the market, or at least know that we disclose that this is not working, property is being sold in its as-is condition. Does that make sense? Seller shall order and pay for any report selected within the 5-day, which is the default amount. Okay, so it has structural, general, the HOA documents, prelims, roof, pool, septic, sewer, and then you can click if there's any other inspections you want to do. G21, exception of to ownership title. Okay, what that means, if you go to section 21, ownership and title and authority, that's basically states that the seller warns that the seller is the owner of the property. No other person or entity has title to the property, and seller has the authority to both execute the agreement and sell the property. Exceptions to ownership, title, and authority are specified in paragraph 2G. So basically, you are the person that has the authority to sell the property, right? So that's just what that stipulation means on the grid. Where are we at? Here we are. Bum, bum, bum. Seller intends to include a contingency to purchase a property. These are for, they want to kind of test the market, right? Look, I'll sell my property, but under the condition that if I can find and identify a property, then, I'll go ahead and sell my property. This is what we call kind of a, what's the good word, that I can use? Is that if I cannot find a property, then I'm not going to sell my property. But if I find a property that I like, then I'll sell my property. It's just yeah, it's a contingency that allows the seller to have that peace of mind that they're not going to be technically homeless when they sell the property, right? So it's a disclosure to the buyer says, hey, we're going to put the property in the market, but also I have to identify a property before I release. And if I don't find a property within the time period, I don't have to sell it. And that's the safe haven position that the seller has, that if they don't find a property they want, then we've already fully transparent and disclosed to the buyer that we have the right to back out of this deal. And the buyer has to be okay with that, as long as we disclose that, right? Because again, we're putting notice saying, hey, we're telling you, if I don't find it, then I don't have to sell it. Okay. Seller opts out if they don't want key, lockbox, or signs. And then additional terms here. This is where you can put like additional names, like if my neighbor sells John Smith, this is where you can put that. The next is the advisories, okay? The advisories that are specific to this agreement. Again, very far and few are we seeing, short sales and real estate, owned real estate. But if it's a trust advisory, then yeah, you would check trust advisory. And then the addendas identified below are incorporated in this agreement. So this is any additional stuff that you want to attach. And this is where, the one that many and myself created, that if the seller does want to pay compensation to a cooperating brokerage, right, then you would include that as part of the supplement, right? So you would check here, and then you would put that specific form as an attachment to the listing agreement, right? So what it says to the seller is, hey, we agree to these terms, but we also have this additional addenda that includes as part of the agreement, and that's that you are willing to pay compensation to a buyer's agent. And then the rest of the stuff is basically just the compensation, just kind of the grid of everything. I'm not going to go too deep into this because it's pretty self-explanatory. I really just wanted to emphasize really on the ins and outs of the grid. Now, just a couple of things that I want you to understand is, like Section F, seller's compensation and obligations, items included and not included, what is leased and what is owned. And one is the broker responsibility and what our limitations are. Okay. So this is one that I want you to understand because, we're limited of what we can and cannot do. So it says broker agrees to exercise reasonable effort and due diligence to achieve the purpose of this agreement. What is the purpose? Sell the home. Right. So unless seller gives us broker written instructions to the contrary, broker is authorized but not required to, one, order reports and disclosures, including those specified in paragraph 7E as necessary, two, advertise and market the property by any method and any medium select by the broker, including MLS and the internet, and to the extent permitted by these media control and dissemination of this information submitted to any medium. And three, to disclose to any real estate licensee making an inquiry and receipt of any offers to the property and offer price of such offer. So this is where a lot of agents get the misunderstanding, okay? And I apologize if I'm going a little over my time. If you need to jump off the call, by all means, please do so, not a problem. But I'm going to continue. And this is also being recorded, so at any given time, you can go back and research this recording. So agents are under the misconception that when I inquire, I call the listing agent and I say, hey, my name is Simon with Keller Williams. My clients are very interested in the property. Can you tell me, do you have any offers? Okay. And, what is the offers do you have? And some agents will say, well, I'm not privy to tell you that information. Okay. I cannot disclose. I cannot say anything, right? Well, that's not the case because under paragraph 7A, it says that, yeah, full disclosure to any real estate licensing, making an inquiry, the receipt of any offers. Do you have any offers on the property and the offering price of such offers? So I can ask the listing agent, and if they say, no, I'm not privileged to give you that, and I ask why, okay, then you can reference it to back to, well, I have to disagree with you because under paragraph 7A, it says that, yeah, you are supposed to let me know, you know. Now, with that said, if you have it in writing from the seller and the seller instructs you to say, look, I don't want you to provide any information to anyone about how many offers or price, then you have the written agreement by the seller. And therefore, then you can say, under the seller's discretion, they have requested that I do not provide that information. Just submit your best and your best offer. Okay. But here it says that you could ask, and the listing agent should be. Okay. Presentation and offer is pretty self-explanatory. I'm not going to go. Buyer supplement of letters, we talked about it. Seller's good faith, obviously, that, you know, the goal and accomplish is that they give us the ability to help sell their property, right? And under good faith that the seller will do whatever we need to do to help accomplish that goal. Investigations, pretty self-explanatory. We talked about that undisclosed conditions or incomplete or incorrect information. Seller further agrees to indemnify, defend, and hold broker. So this is our protection here. So if they want to sue us, then we can always go back and reference like, okay, well, you know, here's the conditions that will identify, because we don't know the property, right? We don't know what's in between the ceiling, right? We don't know that. And it's not our jobs to know. Our job is just to facilitate, find a buyer, find a seller, put them together, close the deal, but we're not experts to the overall condition of the property. Therefore, this is a disclaimer that protects us from those claims. Agency relationship is pretty self-explanatory as part of the process. You know, you have to have an agency agreement when working with anyone. In talking real estate, you have to provide the agency agreement. Termination of agency relationship. Seller acknowledges and agrees that the representation duties of any agency relationship work with the broker terminate at the expiration of the agreement. It doesn't say that we have to cancel anytime within our listing period, okay? But it does say that after it expires. So if it expires in 3 months, it expires, okay? The only way you can continue reviving that is if you do an extension of the listing and give you another 3 months and another 3 months, and that's perfectly fine. But under no circumstances is there any language there that says I have to cancel. Seller, right? You sign a modified bona fide agreement that allows us the opportunity to sell the property. But there's nowhere there says that the seller changed their mind, they want to cancel just because they want to cancel. No, you know, if we put time, effort, and energy, you know, look at the time that you put, the money that you put into it, you know, the hours that you put in an open houses, that's worth money. That's your time, right? So, but there is a cancellation provision that allows us to cancel if you want, you know, mutually agree to cancel because maybe you just don't want to work with the seller anymore. Okay. But there's also a paragraph there that if there was any out-of-pocket expenses that the seller, if they decide to cancel and under our discretion, we'd want to cancel, then they have to at least pay the agent's compensation for it. Otherwise, we can write it into it expires and we can withhold it for the remainder of that expiration. So if the buyer, excuse me, if the seller gave us 6 months and then a month into it decides to cancel, we have the right to say, no, we're not going to cancel. We're just going to withdraw it. And it'll ride for, that means no other agent is able to put it on the MLS. And if they do, they're in breach of contract and then we can go after compensation. Okay. Security insurance, showings and audios, it's just a disclaimer, you know, with technology now, you know, people having surveillance cameras, you know, just safeguard, beware to the buyers and promotions and advertisements, photography and all that, lock boxes and all that. signs, and then, all equal housing opportunities. We don't discriminate, and all anti-discrimination laws. Management approval basically means that within 5 days of you getting the listing, if I don't, as the broker, do not approve it, then I have the right to cancel that. The agent doesn't have the authority, right? If it's something that is a little risky, or just I see some risks involved, then I can pull the listing and ultimately have it canceled. Disputes, again, just like anything, mediation, arbitration advisory. So I'm not going to go deep into it, but again, those are part of the process. If it's an entity, then you would check off the entity seller. If it's a trust, if it's a corporation, LLC that it's signing, we just need to know who are the signers on behalf of the trust entity, S Corp LLC. And then the seller signs the agreement, and you as the agent sign, and that's pretty much it. Any questions, thoughts, or concerns regarding today's topic? Okay, well then that pretty much wraps it up. That concludes our class. If you do have any additional questions for me, please don't hesitate to reach out. I appreciate you all for jumping on the call, and I will see you on the next contract class. Thanks, everyone.
Thank you.
Evan.
Thank you. Thank you.
Bye.
Thank you, everyone.
Have a great weekend.
Thank you. You too.